Greetings, this is Christine on Gibson County, State Coordinator for the Indiana Assembly for Gen Ed Wednesday, as we're continuing with Brent Allen Winter's section of Declaration of 76, United States Constitution. A common lawyer comments, clause by clause, Brent Allen Winters. All right, let's get this up. Okay, Section 8, Clause 12, to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. Comment. This clause is to keep the purse strings in the grip of Congress and out of the hands of the Commander-in-Chief of the Armed Forces, the President. As far back as Magna Carta, 1215, and even further, only the British and English gatherings of elders had right to declare war, to empower their chosen king to command the armed forces by their advice and consent, and to control the resources he needed to wage war. In fact, Magna Carta came about due to the barons' refusal to fund King John's War. The framers knew this history and the destruction that came upon their ancestors when the elders lost control of the resources to wage war to the commander-in-chief's whims. In short, power gathered under a single commanding will, whether of one man or army, is downright dangerous. And remember, says Octon, where you have a concentration of power in a few hands, all too frequently men with the mentality of gangsters get control. History has proven that. Lord Octon, though a staunch Roman Church devotee, derided the Pope's 1853 decree of unlimited power. Any presumption is against the holders of power, increasing as the power increases. Power tends to corrupt, and absolute power corrupts absolutely. Great men are almost always bad men, even when they exercise influence and not authority. Still more when you superadd the certainty of corruption by full authority. There is no worse heresy that the office sanctifies the holder of it. Note well, this clause bars Congress from funding the Army for more than 2 years at a time. Congress's power of the purse, however, is now of no effect because the Federal Reserve Bank now bypassed Congress by printing money for any war or welfare it decides to effect political manipulation. Section 8, Clause 13, to provide and maintain a navy. Comment. This clause accords with the preamble. Our Constitution requires Congress to provide for the common defense. Thus, merely promoting the common defense falls short of our Constitution's requirement. In a word, this clause empowers Congress to buy and build warships, docks, munitions, and shipyards, and to train and pay sailors and shipwrights. Because floating and manning a war fleet requires much time to build and outfit, our Constitution never limits Congress's appropriations of money for the Navy to only 2 years, as it does for funding the Army. Section 8, Clause 14, to make rules for the government and regulation for the land and naval forces. Comment. Again, this clause, as all of our Constitution, is in keeping with the hard lessons learnt and gathered into the common law tradition. The tribes that migrated to Britain empowered their kings as commander-in-chief only after the ruling body of elders had declared war. Moreover, these elders limited this power to their advice on and consent. So also this clause empowers Congress, never the President, to make rules for the government and regulation of the land and naval forces. Not General George Washington, but our early Congress, then governing under the Articles of Confederation, adopted the British Crown's military regulations for our Continental Army and hoped for American Navy. Congress, of course, removed all references to King George III. Section 8, Clause 15, to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Comment. This first of our 4 militia clauses, see also U.S. Constitution, Article 1, Section 8, Clause 16, Article 2, Section 2, Clause 1, Amendment 2, empowers Congress alone to set standards and rules governing when, on what conditions, and how the President shall call forth the militias for service. The militia, being the people themselves, is no creation of our Constitution. Rather, our Constitution, recognizing its existence, provides preset procedure for its use. In fact, because the militia is the people themselves, government decree can never end it or its duty. Further, Congress's power to do so is non-delegable. No president has the right to decide by his own standard or lack thereof whether an invasion or local insurrection, an uprising, warrants his calling up the militia. If Congress neglects to provide this standard, its members have failed their sworn duty. Congress's duty to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions needs be cast in a standard order so that in an emergency the President can act with dispatch. If the emergency meets Congress's preset standards, the President must call forth the state militias needed. Note well, the militia of the several states are not the National Guard, but rather embrace every able-bodied man. Further, as with the Anglo-Saxon kings' authority over the feared militia, the President is the sole judge, using the standard Congress has provided concerning whether any given exigency requires that he call out any state militia. See this handbook, U.S. Declaration of 76, sections 8 to 29 and comments. A related common law and constitutional concept are the jury, a special form of the militia called out and impaneled under oath to hear evidence in a trial and render a verdict, or to investigate a public matter and render a presentment or indictment. Grand jury. In the notes, even the federal courts claim authority of our Constitution to call out the militia to enforce their writs against the President. Supreme Court Justice Taney, while sitting as federal district judge, never doubted the court's authority to have the federal marshal call out the state militia to enforce the writ of habeas corpus against the United States Army. He pondered, instead, the ability of the militia to enforce the writ given the power of the Army regulars. The court's marshal said the Chief Justice had right to summon the posse comitatus, local state militiamen, to aid him in seizing and bringing forth before the court the party named in the writ, General Cadwalader, who would, when so brought, be liable to punishment by fine and imprisonment. But where, as in this case, the power refusing obedience, the United States Army, was so notoriously superior to any the marshal could command in the militia, he excused the marshal from doing anything more than he had done. Referencing Ex parte Milligan 4 Wallace 2, 1866. See Martin v. Mott, 12, Wheat 29, 1827, Justice Story. I'm figuring is that. See also U.S. Constitution, Article 1, Section 8, Clauses 15 to 16. Although Congress is to provide for the calling out of the militia of a state or states, the President holds sole discretion, says Justice Story, under standards Congress sets to decide whether or not to do so. Likewise, chieftainships of the Anglo-Saxon tribes, as also presidents of the United States, had jurisdiction only over the called out or the militia a-going. Anglo-Saxon feared fair, i.e., mustered and awaiting further orders. Okay. Section 8, Clause 16, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states, respectively, the appointment of the officers and the authority of the training the militia according to the discipline prescribed by Congress. Comment. Americans have never amended this militia clause. Its straightforward meaning gives the right understanding. Again, National Guard units are not the militia. By the term militia, the American colonial signified both the militia, having yet to answer any call to muster, and the separate militia of the several states having answered the call to muster. The militia in colonial America, says the Supreme Court, consisted of a subset of the people, male, able-bodied, and within a certain age range. Although the militia consists, note well, present tense, i.e. today, of all the able-bodied men, the federally organized militia may consist of a subset of them, called forth in a local place to meet a local threat. D.C. v. Heller, 554 U.S. 570, 2008. Our Constitution allots concurrent authority over the militia to each of the states and Congress. The militia clauses empower Congress to enact rules for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States. The states retaining authority to appropriate officers and impose the training Congress sets forth. This militia clause gives the general government no authority to provide arms, equipment, or pay to any militiaman until the President has duly summoned that militiaman. He has answered the summons and is mustered in. At that point, this militia clause grants authority to Congress to fill his hand to do his duty. The Militia Act of 1792 was Congress's first legislation on this matter. Every free, able-bodied white male citizen of the respective states resident therein, who is or shall be of age of 18 years and under the age of 45 years, shall be enrolled in the militia and shall within 6 months thereafter provide himself with a good musket or firelock. Later, Congress's Militia Act of 1903 said that the common law militia is always in one of two postures. The unorganized militia, embracing all able-bodied males between ages 17 and 45, except armed forces regulars, certain officials, and others per 10 U.S.C. subsection 311, and the organized militia, which is the unorganized militia called out and mustered. This legislative distinction between the organized and unorganized militia is beyond the contemplation of the Constitution's use of the phrase the militia. To be sure, this clause tells Congress to prescribe rules for organizing the militia. The Constitution nevertheless presumes operation of the common law requirement. The militia can never be unorganized, i.e., unready, less than regular. In fact, when our Constitution was accepted, the militia of each state was organized, and this clause leaves the organizing to each state, but transfers to Congress authority to provide rules governing how the states are to go about the task. Congress legislates, the states execute. Hence, whether called out and mustered or not, all able-bodied men from 16 to 60 remains by our Constitution's common law the militia organized, i.e. regular. All like provisions of state constitutions are good law, except where any clash One cannot obey both at the same time with Congress's constitutional legislation, in which case the Supremacy Clause of Article 6 overrides the contrary state law. See Houston v. Moore, 5 Wheat 1, 51, 1820. See also U.S. Constitution, Articles 1, Section 8, Clauses 15 to 16. See Federalist number 4J, numbers 25, 28 to 29, 69 from Hamilton, numbers 41, 45 to 46, 56 from Madison, discussing the common law militia. To sum up, whether or not having answered any call, the militia are always regular, armed and ready. Further, militiamen, says Justice Story, are subjected to martial law only when in actual service and not merely when called forth before they have obeyed the call. Thus, the militiaman, by his answering the call, not by the government merely making the call, brings himself under martial jurisdiction under his lawful release from duty. By Amendment 2's requiring that each militia member furnish his own firearm and training, i.e. discipline to its use, our Constitution confirms the common law militia. Further, as did the English Knights fee, our militia provides for the common defense, largely in men instead of tax dollars, thus reducing the possibility of unlawful spending and temptation to hire mercenaries. Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may, by cession of particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state, in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Comment. This clause gives Congress exclusive and full legislative power not only over the District of Columbia, but also over all federal military property called federal enclaves. Land it has obtained for military purposes only by consent of the state wherein it lies, and upon which it has erected forts, magazines, arsenals, dockyards, and other needful buildings. In addition, it ensures to each state legislature the power to refuse consent to the general government's request to build military works and structures within the state's borders. However, once a state has of its own consent transferred such land title to the federal government, and that government has erected structures for military purposes, as long as that land is being used for military purposes, that state is without right to demand return of that land to the exclusive jurisdiction of the state's laws. Section 8, Clause 18, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Comment. This is the necessary and proper clause, allowing Congress to deal with matters our Constitution never mentions, but which are nonetheless necessary to carry out powers the Constitution lists. Being necessary under this clause, however, never allows Congress open-ended power. Thus, even though an act of Congress is necessary, government must carry out such an act in keeping with all of the Constitution's other demands and restraints under due process, which is the course of the common law. See this handbook, U.S. Declaration of 76, sections 3 to 5, 7 to 8, and comments. In all events, the word necessary and proper include no power to pass criminal statutes, take criminal jurisdiction over a matter, or otherwise seek a prescribed result. In sum, the words necessary and proper are not words of raw power, but words of administration and process. Let the chips fall where they may. Where the right process is followed, our Constitution ratifies the result. And we'll pick up on the next call. Peace and love.